All right, get ready, because we're diving straight into the deep end today.
Yeah, no messing around.
We're tackling criminal law in England and Wales, and you know what that means.
Essential stuff for anyone prepping for the SQE.
Absolutely. So we're zeroing in on legal aid, those all-important police powers, and the ins and outs of court procedures.
Think of it as like a cheat sheet.
Exactly, cutting through all that legal jargon so you can get right to the heart of it.
No time wasted.
So first things first,
Legal aid.
you absolutely need to know if you can even get it right.
Right, it all comes down to two key tests.
Okay, lay them on me.
The means test and the merits test.
Means test. So that's all about whether you can actually afford a lawyer.
Exactly. There are some very specific income thresholds and calculations.
Okay, so break it down for me. What are the actual numbers someone would need to know?
All right, so if your annual income is less than $12,475 downs,
Less than $12,475.
you automatically pass the means test.
Simple enough.
But if it's between $12,475 and $22,325,
That's a tricky zone.
things get a little more complicated. They'll take a close look at your disposable income.
Disposable income, meaning what's left after all those essential living costs.
Precisely. And if that disposable income is $3,398 or less, you're still in the clear.
Okay, that makes sense. But there's always a but.
What if someone earns just a bit more than those thresholds?
Are they just completely out of luck?
Not necessarily. That's where the merits test steps in.
Ah, the merits test. So what does that one look at?
This one's all about how strong your case is.
So is it really vital for you to have legal help to get a fair trial?
Exactly. We're talking about those big interests of justice factors.
What kind of factors are we talking about?
Think like a high chance of going to prison if you're found guilty.
Okay, that's pretty serious.
Or you could lose your job, damage your reputation.
Those are all huge,
Or maybe the legal arguments are super complicated.
requiring an expert to really cross-examine witnesses.
Exactly.
So even if someone's earning a decent income, they could still get legal aid if the stakes are high enough.
Exactly. It's about leveling the playing field a bit, making sure everyone has a fair chance, regardless of their financial situation.
Absolutely. So we've covered legal aid now. Let's shift gears a bit.
Let's talk about those encounters with the police.
Because let's face it, those can be a bit stressful, to say the least.
Yeah, knowing your rights when you're being arrested or searched is absolutely crucial.
So cut to the chase. What are the police actually allowed to do?
Okay, well, it's important to remember police powers aren't limitless.
That's reassuring.
So for stop and search, they need what's called reasonable suspicion,
Okay, reasonable suspicion.
meaning they have to have a good reason to think you might be carrying something you shouldn't.
Like what?
It could be stolen goods, something you're planning to use for a crime, a weapon.
Okay. Or illegal drugs.
Right.
And for an arrest.
They have to have reasonable grounds to believe you've actually committed an offense.
So not just a hunch.
More than a hunch, for sure.
How would you even prove reasonable suspicion in court? And it sounds a bit vague.
It is a key legal principle, but it can be subjective.
But it's got to be based on something concrete, right?
Absolutely. The officer has to be able to clearly explain their suspicion based on actual facts, intelligence, or even your behavior.
So it's not enough for them to say, I just looked suspicious.
No, definitely not.
And they can't just stop and search me on a whim, can they?
No, they have to follow certain rules.
Like what?
They have to tell you they're stopping and searching you, what grounds they have for doing it, what exactly they're looking for, and the reason for their suspicion.
And they have to be respectful, right? I mean, maintain some privacy.
Absolutely. Treating you with respect is a must.
Okay, what about entering and searching someone's property? Do they always need a warrant for that?
Not always. There are exceptions.
I was hoping you'd say that. Like what?
If they're in hot pursuit of someone for a serious crime.
Like an indictable offense.
Exactly. Or if they need to prevent someone from being seriously harmed, those are times they can enter and search without a warrant.
But they still have to have a lawful reason for entering, right?
Absolutely. The grounds for entry still have to be lawful.
So if I see police at my door, I shouldn't just assume they have a warrant to be there.
That's right. If you're at all unsure about the situation, it's always best to get legal advice.
Better safe than sorry.
Exactly.
Okay, so let's say they do take you into custody.
Detention and questioning.
Things can get a little intense there.
Definitely a situation where knowing your rights is essential.
So what's the longest they can actually hold you without charging you?
Those custody time limits are pretty strict.
I bet. So how long are we talking?
Well, initially it's 24 hours from when you arrive at the station.
Okay, 24 hours.
But it's not a free-for-all. A review officer checks on your detention regularly.
Regularly, how often?
After 6 hours, then again at 9 hours, and then another review at 9.
So they can't just keep you locked up forever?
Not at all. Those reviews are there to make sure your detention is justified and the investigation is moving forward properly.
And what about for those serious offenses, those indictable ones?
Well, a superintendent can actually authorize extending the detention up to 36 hours in those cases.
So 36 hours max.
Not quite. If they need to hold you longer than that,
Longer than 36 hours.
then they need a warrant from the magistrate's court.
Okay, to keep you in custody even longer.
Right. The court can initially grant up to 36 more hours and then another 24 if they need it.
So the absolute maximum is 96 hours.
Precisely. You start with that initial 24 hours, then a possible 12-hour extension from the police, and then potentially up to another 60 hours with those court warrants.
Wow, that's a lot of time.
It is a significant chunk of time.
What about your rights during all that detention? I mean, can you at least make a phone call?
Absolutely. You have the right to inform someone about your arrest, the right to talk to a lawyer.
And you have to be held in decent conditions, right?
Of course, appropriate conditions are essential.
What about informing someone? Are there ever times when they wouldn't let you do that?
There are some very specific situations where the police can delay that, right?
Like what kind of situations?
For instance, if they think it could lead to someone interfering with evidence or tipping off other suspects.
Makes sense, or if it would make it harder to recover stolen property.
Right, but those exceptions are limited, and the police have to have a good reason to use them.
They can't just invoke them on a whim.
Exactly.
What about talking to a lawyer? Can they delay that right too?
That's a fundamental right. The police have to tell you about it straight away.
Okay, so they can't stop you from getting legal help.
Right, they can't discourage you from seeking advice, and they can't interview you if you've asked for a solicitor and haven't had the chance to speak with them yet.
So, similar to informing someone, they can delay access to legal advice, but only under very specific circumstances.
Exactly. And they still have to be able to justify that delay.
They can't just say, nope, not today.
Right, the reason has to be serious and directly related to protecting their investigation.
It sounds like even when you're in custody, your rights are still protected.
That's the idea.
Okay, now on to a big one, the right to silence.
Yes, a classic.
It always seems a bit confusing to me. When is it actually smart to stay quiet, and when could it backfire?
It's tricky. You have the right to remain silent when the police are questioning you. But there's this thing called adverse inferences.
Adverse inferences? What does that even mean?
It means the court might draw negative conclusions from your silence.
So staying silent could actually hurt your case.
It's possible, let's say you later bring up a fact in court that you could have reasonably mentioned during questioning.
And you didn't.
The court might think, well, why didn't you say that before? Did you just make it up?
That's a tough spot to be in.
It's a balancing act, for sure.
So what other options are there besides just saying no comment to every question?
You could give a prepared statement. It's a way for you to give your side of the story, but in a controlled way, without all the pressure of direct questioning.
So I could have my solicitor write up a statement that lays out my defense.
Exactly. That way, you're on record with your version of events, but you're not subjected to potentially tricky questions.
That sounds a lot safer.
It helps protect you from accidentally incriminating yourself.
And it reduces the risk of those adverse inferences.
Right. It shows that you've been consistent with your story all along.
I mean, it makes sense giving a prepared statement. Are there any downsides to doing that?
It has to be carefully written to address all the relevant points. If it's incomplete or you later change your story, the court might still wonder why you didn't mention certain things before.
So it's not a foolproof plan.
No, but it can be a valuable tool in the right circumstances.
Okay, something to discuss with the solicitor.
Definitely.
So we've talked about staying silent and giving a prepared statement. What about just answering all their questions?
You can do that, but it comes with risks.
Risks like what?
You might accidentally say something that hurts your case, or their questions might lead you down the wrong path.
So even if you're innocent, talking to the police could backfire.
It's possible. They're building a case, remember?
And they might not always be looking for the absolute truth.
It's not always their top priority.
This is all starting to make a lot more sense. How do you decide which strategy is best?
It all depends on the specifics of your case.
No easy answers.
Not really. Your solicitor will help you look at all the evidence, figure out the risks and benefits of each option, and come up with a plan that's tailored to your situation.
So having a good solicitor really is essential.
Absolutely. They're your advocate, your guide, especially during something as stressful as police questioning.
Couldn't agree more. Okay, so let's move on then.
Let's look at what the prosecution needs to do to prove their case.
All right, what do they have to prove to actually get a conviction?
Well, They have what's called the burden of proof,
The burden of proof.
meaning they have to prove beyond a reasonable doubt that you committed the offense.
Beyond a reasonable doubt.
Right, and that involves proving two essential elements, actus reus and mens rea.
Ah, yes, the classic duo. Remind me what those are again.
Actus reus is the guilty act.
Okay, the physical part of the crime.
Right, so in a theft case, the actus reus would be the actual act of taking the property.
Makes sense, but it's not enough to just prove that, right?
Exactly, they also have to prove mens rea,
Which is?
the guilty mind.
So they have to show that I intended to commit the crime?
It depends on the specific offense.
Oh, okay, so how does that work?
Some crimes require what we call specific intent.
A specific intent, meaning...
It means you acted with a particular purpose in mind.
All right, and what about the other kind?
Other offenses only require basic intent.
So for basic intent, just being reckless is enough.
Exactly.
Can you give me some examples?
Sure, so theft is a specific intent crime.
Theft is specific.
They have to prove that you intended to permanently deprive the owner of their property.
You took it, you meant to keep it.
Right, but assault, on the other hand...
That's basic intent.
Exactly. It's enough to show that you were reckless about causing harm. You didn't necessarily need to intend to hurt someone.
Interesting. So even if I did the guilty act, I might not be guilty if I didn't have the right mental state.
That's the idea. Both actus reus and mens rea have to be there for a conviction.
Okay. What about defenses? Can I argue that I had a good reason for doing what I did?
Absolutely. There are a lot of different defenses you can raise depending on the circumstances.
Like what?
Some common ones include self-defense, duress, mistake.
Okay, break those down for me.
If you were being attacked and you used force to protect yourself, that would be self-defense.
Okay, makes sense.
Or let's say you were forced to commit a crime because someone was threatening you with violence. That would be duress.
So you're saying you were under extreme pressure?
Exactly. And if you genuinely believed that you were acting within the law,
Even if you weren't?
you could argue mistake.
Interesting. So even if they prove actus reus and mens rea, a solid defense could mean you're not guilty.
Precisely. Defenses are a really crucial part of making sure the justice system is fair.
This is all so helpful. I'm starting to feel much more prepared for the SQE now.
That's great to hear.
Knowledge is power, especially when it comes to the law.
I couldn't agree more.
Okay, so now that we've covered what the prosecution has to prove.
Let's move on to what happens after you've been charged with an offense.
Okay, let's talk about bail and those court proceedings.
Sounds good.
Okay, so let's say the worst has happened and I've been charged. What happens next?
Well, first things first, you'll have your first appearance at the magistrate's court.
Does everyone go to magistrate's court?
Yes, in England and Wales, all criminal cases start there.
Even the really serious ones that end up in Crown Court?
Even those.
Interesting. So what happens at that first appearance?
It's like a preliminary hearing, really.
So sorting out the admin stuff?
Exactly. Things like bail arrangements, legal aid, and setting a timetable for the case.
Okay, and then what?
Well, it depends on the type of offense you've been charged with.
Type of offense, meaning?
There are 3 categories:
Hit me with them.
summary-only offenses, either-way offenses, and indictable-only offenses.
Okay, let's break those down. What are summary-only offenses?
Those are the least serious ones.
Give me some examples.
Think minor traffic violations, common assault, things like that.
Okay, so low-level stuff.
Right, and those are handled entirely in the magistrate's court.
So if you plead guilty,
They'll sentence you right then and there.
and if you plead not guilty.
Then they'll schedule a trial, which will be heard by either magistrates or a district judge.
And what's the worst they can do sentence-wise?
For a single summary-only offense, the maximum is 6 months in prison.
Okay, 6 months.
And they can also give you an unlimited fine.
Unlimited, wow.
But if there are multiple summary offenses, the total prison time can't be more than 6 months.
Got it. So that's summary. Only what about either-way offenses?
These are sort of the middle ground.
Middle ground, how so?
They can be tried in either the magistrate's court or the Crown Court.
Okay, so how does that work? Who decides?
The magistrate?
They decide where the case will be heard.
Right. They look at the case and figure out if they have enough sentencing power to deal with it.
So if they think it's too serious...
Then they'll send it up to the Crown Court.
Okay. And what if they think they can handle it?
Well, even then, you can choose to have your case heard in Crown Court if you want.
Wait, so I have a say in it.
You do.
But why would someone choose Crown Court if the magistrates are happy to hear the case?
A couple reasons, actually.
Like what?
In Crown Court, you'll have a jury.
Instead of just the magistrates or judge.
Right, and a jury might be more sympathetic to your case.
Okay, so there's a chance of leniency there.
And Crown Court also has much greater sentencing powers.
So it's a gamble.
It is. You could get a lighter sentence or you could end up with a much harsher one.
A lot to think about.
Definitely. Something you'd want to discuss carefully with your solicitor.
Okay, last category then, indictable-only offenses.
These are the most serious crimes.
We're talking murder, manslaughter.
Exactly. Rape, robbery, those kinds of offenses.
So straight to Crown Court for those.
Always. There's no magistrate's court option for those.
Okay, so what happens in Crown Court?
Well, you'll have a plea and trial preparation hearing.
Catchy name.
Right. If you enter a guilty plea at that hearing,
Then what?
they'll set a date for your sentencing.
Makes sense. But if you plead not guilty.
Then they'll schedule a trial, and that trial will be before a judge and jury.
Okay, so for those serious indictable-only offenses, it all comes down to the jury.
Exactly. They'll hear all the evidence and decide whether you're guilty or not guilty.
And what happens if they find you guilty?
Then the judge will decide on your sentence.
Based on what?
A lot of factors, actually. The severity of the crime, obviously, your past criminal record, and any mitigating circumstances.
Mitigating circumstances meaning?
Things that might make your offense seem less serious.
Okay, got it. So let's say I've been found guilty, whether it's in magistrate's court or Crown Court. What happens at the sentencing?
Well, first, both the prosecution and the defense get to have their say.
Meaning?
The prosecution will try to argue for a tougher sentence.
By pointing out things that make the crime seem worse.
Exactly. Things like if the crime was planned out, if a weapon was used, if the victim was particularly vulnerable.
Okay, so they're really pushing for a harsher punishment.
Right. But then your solicitor will argue for leniency.
By focusing on.
Mitigating factors, things that might make the offense seem less serious.
So showing that I'm not a complete monster.
While more like highlighting things that might make the judge more sympathetic. Genuine remorse, cooperating with the police, a difficult personal history, things like that.
So my solicitor's job is to basically paint me in the best possible light.
Pretty much they're trying to persuade the judge to give you a lighter sentence.
Okay, that makes sense. So once everyone's had their say, the judge decides on the sentence?
That's right.
And what kind of sentences are we talking about here?
Well, they have a range of options. They could give you a fine, a community order, or imprisonment.
Okay, let's go through those. What are community sentences exactly?
Those are punishments that you serve in the community rather than in prison.
So you're still being punished, but you're not locked up.
Right. They often involve things like doing unpaid work in the community, having a curfew, or participating in rehabilitation programs.
So the idea is to hold you accountable without resorting to prison.
Exactly.
But it's not exactly a walk in the park, is it?
Not necessarily. A community order can last for up to 3 years.
3 years.
And it can have lots of different requirements that you have to meet.
So what happens if someone just ignores the terms of their order?
They can be brought back to court
Yeah.
and face an even harsher punishment, like additional requirements or a fine.
Or even prison.
In some cases, yes, the court could revoke the community order and send you to prison instead.
So it's not something to be taken lightly.
Definitely not. Community sentences are meant to punish and rehabilitate, not offer an easy way out.
Okay, what about fines?
Fines can be given for a pretty wide range of offenses, actually.
Not just minor stuff.
No, they can be imposed for everything from minor traffic violations to more serious crimes.
And how much do you have to pay?
That depends on how serious the offense is and how much money you have.
So a wealthy person might get a bigger fine for the same crime as someone who's not so well off.
That's the idea. The punishment should be proportionate to your ability to pay.
Makes sense. And then there's imprisonment.
Right. That's obviously the most serious punishment.
Reserved for.
The most serious offenses and the most dangerous offenders.
The ones who pose a real risk to the public.
Exactly.
So how does the judge decide how long someone should go to prison for?
Well, they follow sentencing guidelines.
Sentencing guidelines.
Yeah, these guidelines basically set out a starting point and a range for each type of offense.
Okay, so there's a framework to work within.
Right. And then the judge adjusts the sentence up or down based on those aggravating and mitigating factors we talked about.
So two people could commit the same crime, but get totally different sentences.
Absolutely. Sentencing is very much tailored to the individual offender and the specific circumstances of the crime.
Okay, that makes sense. What about early release? Do people always serve their full sentence?
Not always. For most sentences, people are eligible for release on license after serving half of that time.
Release on license meaning?
It means they're released from prison, but they have to follow certain conditions.
Like?
Things like living at a specific address, regularly reporting to a probation officer, staying away from certain people or places.
So they're not completely free?
No, they're still under supervision.
And what happens if they break those conditions?
They can be sent back to prison to serve the rest of their sentence.
Okay, got it. So let's say I've been sentenced. Is that it? End of story.
Not necessarily. You have the right to appeal
Appeal the conviction.
the sentence.
Either one. If you think the court made a mistake or the sentence is too harsh, you can appeal.
Okay, and how does that work?
Well, the process is a bit different depending on whether you were tried in magistrate's court or crown court. Walk me through it.
All right, so let's start with magistrate's court. If you're convicted there,
Yeah.
you can appeal to the Crown Court, and they'll basically rehear the entire case.
Wow, a whole new trial.
Pretty much, and then they'll make a brand new decision on whether you're guilty and what your sentence should be.
Okay, and what if I'm still not happy with the Crown Court's decision? Can I appeal again?
It gets a bit trickier at that point.
Trickier how?
You can't just appeal because you don't like the outcome.
So I need a good reason.
You have to be able to show that the court made a serious legal error.
Okay, some solid grounds for appeal.
Exactly. You could appeal to the High Court on a point of law,
A point of law.
meaning there was a mistake in how the law was applied.
Okay. Or,
Or you could ask the Criminal Cases Review Commission to look at your case.
who are they?
They're an independent body that investigates potential miscarriages of justice.
So they look for cases where someone might have been wrongly convicted.
Exactly. And if they think there's something to your case, they can refer it back to the Court of Appeal.
Interesting. So there's like a safety net built into the system?
Exactly. They're there to make sure that justice is done.
Okay, what about appeals from the Crown Court? How do those work?
For those, you appeal to the Court of Appeal, but you need their permission first.
So it's not automatic?
No, they'll only grant permission if they think there's a real chance of overturning the conviction or reducing the sentence.
So they're only interested in cases where there might have been a serious problem with the original trial.
Right. They don't want to waste time on cases where the outcome is unlikely to change.
Fair enough. And if the Court of Appeal rejects my appeal, is that it? Game over.
Not necessarily. You could still ask the Criminal Cases Review Commission to look into your case.
So that's always an option.
It is. They can refer cases back to the Court of Appeal if they find new evidence or they think a serious injustice has occurred.
So even if you've been through all the appeals, there's still a chance for your case to be reviewed.
That's right. The system is designed to be as fair as possible, and that includes having ways to correct mistakes.
That's good to know. This is all incredibly helpful. I feel much more clear on what to expect at each stage.
That's what we're here for.
Speaking of help, let's talk a bit more about the role of a solicitor.
Absolutely. I mean, we've touched on it throughout this deep dive.
But it really seems like having a good solicitor is absolutely crucial when you're facing a criminal charge.
I couldn't agree more. Your solicitor is your guide, your advocate, your confidant, really throughout the whole process.
So from the moment you're arrested, you should have a solicitor with you.
Ideally, yes. You have the right to free advice from the duty solicitor at the police station.
Okay, so you're never completely on your own.
Right. And if you're facing serious charges, you'll definitely want to instruct a solicitor to represent you throughout the entire process.
So what should you look for in a good criminal solicitor?
Well, experience is obviously key. You want someone who knows the courts inside and out, someone who understands the procedures and the specific offenses you're facing.
So someone who's been there and done that.
Exactly. You also need someone who's a good communicator, a skilled negotiator, and a fearless advocate.
Someone who can explain things clearly, fight for your rights, and make you feel comfortable and confident.
Precisely. Having the right solicitor can make all the difference in the world.
It sounds like it. They can help you understand your options, make informed decisions, and hopefully get the best possible outcome.
That's the goal.
This has been such an insightful deep dive. I feel like I have a much better grasp on the whole criminal justice system now,
I'm glad to hear that. Knowledge really is power.
especially when it comes to something as complex as the law.
For sure.
So, as we wrap things up, is there any other important advice you'd give to someone who's facing a criminal charge?
Stay informed, know your rights, and get legal advice as early on as possible.
The sooner the better.
Absolutely. The more prepared you are, the better you'll be able to handle whatever comes your way.
Sound advice, and remember, even if it feels overwhelming, you don't have to go through this alone.
That's right. There are people who can help you and make sure your rights are protected.
That's reassuring to hear. Well, this has been incredibly helpful. Thank you so much for joining us on this deep dive into criminal law and procedure in England and Wales.
It's been my pleasure.
And to our listener, we hope this deep dive has given you valuable insights and maybe even a sense of empowerment. Remember, every case is unique, so if you're facing a criminal charge, Reach out to a qualified solicitor to discuss your specific situation.
And remember, never underestimate the importance of understanding your rights.
Well said. That's all for this episode of The Deep Dive. We'll catch you next time for another in-depth exploration of a fascinating topic.
Until then.
Wow, it's incredible just how much there is to know about criminal law.
It's a vast and complex area of law, that's for sure.
It really highlights how important it is to have good legal representation.
Absolutely. The stakes can be incredibly high. The law itself is intricate. And having a skilled solicitor by your side can truly make all the difference.
You've been an amazing guide through this whole legal maze. I feel like anyone prepping for the SQE would benefit immensely from listening to this deep dive.
Well, that's the aim, to shed some light on these complex legal processes and empower people with knowledge.
So as we wrap things up here, is there one final piece of advice you'd give to our listener who's gearing up for the SQE?
I'd say focus on really understanding the principles behind the law. Don't get bogged down in memorizing every single detail.
So it's more about understanding the big picture.
Exactly. The SQE is designed to test your ability to apply legal knowledge to real-life situations, not just regurgitate facts.
So think critically, strategically, kind of like a solicitor would in practice.
Precisely. Practice applying the concepts we've discussed to different scenarios, analyze fact patterns, and try to identify potential legal arguments.
Great advice. Any other study tips you can offer for tackling the SQE?
I'd recommend working through as many practice questions as you can and try to do them under timed conditions. It'll help you get used to the pressure of the exam environment and figure out where your strengths and weaknesses lie.
That's a really good point. Anything else our listeners should keep in mind as they're preparing for this beast of an exam?
Remember that the SQE is just one step on your journey to becoming a solicitor. Stay focused, believe in yourself, and never stop learning.
That's a great message to end on. The legal world is always changing.
Exactly. A commitment to continuous learning is essential for anyone who wants to have a successful legal career.
Couldn't agree more. Well, thank you so much for taking the time to share your expertise with us today. This has been a truly insightful deep dive.
It's been my pleasure. And to our listener, I want to say best of luck on your SQE journey. The legal world needs bright, dedicated individuals like you. So stay focused, stay curious, and never be afraid to challenge yourself.
Well said. That's all for this episode of The Deep Dive. We'll catch you next time for another insightful exploration.